Hello and welcome to another session from Ekcel Academy. In this session, we are going to focus on the subject Economic, Commercial and Intellectual Property Laws. If you don't know me, I am CS Swati Sharma, a faculty at Ekcel Academy where I focus on the law subjects. What is the focus on today's session? Our focus is the intellectual property laws. But which is the topic that we are going to cover? For that, let's have a quick look at few of the pictures that I've put in this particular slide. Can you identify any one of the product that I have displayed in this slide? How many of the products do you know or are aware of? So let's have a look at each one of these images and products one by one. The first one is an orange. These are oranges, and in India we know that the oranges are famous from the city of Nagpur. We call them as the Nagpur oranges. Next, second one is a shawl which is made out of wool and the weaving procedure is taking place. The wool in our country is famous from Jammu and Kashmir because of the quality of the wool that is there according to the weather conditions. These are called as the Pashmina shawl. Third one is a footwear. It is a chappal, and these chappals are called as the Kolhapuri chappals because of the design and the material that is used to make that footwear. These are called as Kolhapuri chappals. The fourth product is a tea that is famous from the city of Darjeeling. The next one is a painting, and this painting is famous from the city of Tanjavur, so we call it as the Tanjavur paintings. It is famous for its handwork, and the actual gold foil is used to make this particular painting. So that is the feature of that painting. This is a sweet. It is called as the Dharwad Peda, famous from a city called Dharwad in Karnataka region. Then we have the soap that is known as the Mysore sandal soap. These are various products from different categories. You have few from the agricultural sector, you have some from the food sector, you have something from the manufactured sector, you have something from the handicraft sector. All of these are products belonging to different categories. But what is one common thing that is there in all these products? The one common thing is all of these products are known from the locality, are known from the region, are known from their geographical location. They are identified with the place. Oranges, Nagpur oranges. Nagpur is a city in Maharashtra. Kolhapuri chappal, Kolhapur, Sholapur is a place. Tanjavur from Tamil Nadu, Dharwad from Karnataka. These products are known from their location, from their locality, from the place of origin. This is what we call as geographical indications, and that is the subject or topic for discussion in today's session, which constitutes a part of lesson number 19 of your syllabus, law relating to geographical indications. Before getting into understanding what is a geographical indication, let's have a look at the regulatory framework. What are the laws that govern a geographical indication? Predominantly at the global level, you have the World Trade Organization's TRIPS agreement, that is trade related aspects of intellectual property rights. That agreement, article 22 to 24 of the TRIPS agreement, exclusively deals with the geographical indications and the legal protection that is to be given to geographical protection. Because India became a signatory through the TRIPS agreement, we also, by the virtue of that commitment, have to have a law at the national level where we have passed the GI Act of 1999, that is called as the Geographical Identification of Goods. Registration and Protection Act of 1999. Wherever you know that you have an enactment, to implement the provisions of the enactment, we have to have certain rules. So the GI rules of 2002 are also applicable. So this is the law that is applicable for the concept of geographical indication. The first one being the law at the global level, applicable to all the member countries who have been a signatory to the TRIPS agreement, and by the virtue of that, having the national laws, we have the GI Act and the GI rules. So these are the provisions that we have to cover with respect to GI. But are we going to study the entire regulatory framework in this session? The answer is no. We are going to concentrate on the basic foundational aspects of understanding what is a geographical indications and the basics of this particular chapter. So let's begin with identifying what is a geographical indication. I have given you a few examples. I have told you also that the products are linked to a particular location and that is why they are famous. But what is a geographical indication? Geographical indication is nothing but a hint. It is an identification that one particular product is associated with one particular region, locality, state, country, and that country adds some kind of value to the product. The product is famous because of its uniqueness, some kind of characteristics, some kind of key features. Those key features are there in the product merely because of their geographical location. For example, let's take the Nagpur oranges. It is not that oranges are grown only in Nagpur. Oranges are grown in other locations as well. But why are the Nagpur oranges famous? They are famous because they have certain unique feature with respect to the flavor of the oranges. And why do the oranges which are grown in Nagpur have a special flavor or a distinctive flavor? It is because of the soil conditions. The soil that is there in the land of Nagpur, the weather conditions, the heat conditions, all these accumulated together gives a separate, different, distinctive flavor and the level of acidity to the fruit of orange grown in the region of Nagpur. That is why they are famous. Right? So what is a geographical indication? Geographical indication is nothing but a hint. It is an identification that one product belongs to one locality or one region because that region is adding some kind of distinctive value, distinctive feature, distinctive characteristic or a certain set level of quality to that particular product. And when you have this link that is established, you can call a product as a geographical indication. The product can be known from the region where it is originating. So what is the basic requirement for calling a product as a product capable of claiming a geographical indication? First one is that there should be an existence of the product. Second requirement is that that particular product is associated to some kind of geographical location. And third requirement is that it has some kind of key characteristic, some kind of uniqueness, some kind of distinctive feature, some set level of quality standards, and these quality standards are there in the product merely because of the geographical location. So this triangle should be established that the product is from a particular geographical location. That geographical location is adding some kind of key factor or unique feature to the product. And these three things put together in one particular product will make it eligible to be called as a GI product. And if you have a product which is from a particular location, it has some unique features, then you can register your product as a geographical indication or GI tagged product by claiming registration under the provisions of the GI Act 1999 by making an application to the registrar. This is the basis of geographical indication. Now let's have a look at the theoretical concept of what is it. Like I told you, it is merely an identification, it is merely an hint that one particular product is connected to one specific region, and that connection that is established between the product and the region is solely because of one thing, that that region adds some kind of quality, some reputation or unique characteristic to the product. So what? There is a product, there is a good, and please remember there is no services that comes under the ambit of GI, because the name itself is clear, Geographical Indication of Goods, Registration and Protection Act. So, we are only going to specifically concentrate on goods and products. So, the goods should be related to some kind of location, and this relationship between the goods and the location is established because of some kind of uniqueness, some kind of distinctive feature. If this link is established, then you can say that product is capable of being identified as a GI product. I hope the basics are clear. Now, let's look at how did the concept of GI come into existence. Trace back, go back to the history when we did not know how many continents are there, what is the map, where are the countries, what are the continents. We were not aware of anything. People were only discovering new things. They were moving around locations to find new places, to find new products. And this search led to people coming to the continent Asia, coming to the country India, and identifying that they get something called as silk, they get something called as cotton, they get something called as spice, and these silk, cotton, spice that was found in India was of premium quality, was high standards, were genuine products. They were so good in their quality that people started identifying that if you want cotton, if you want silk, go to India. So, the products started being identified with the location from where they are coming. This led to also the discovery of newer sea routes, newer continents, and that is how a lot of discovery of products and places have taken place. So, when you know that these products are there and these products are available in this location, that is how the concept of linking a product to a particular location began. But what happens with that? With that, what happened? Like I told you, identification started, that all those regions where these products like silk, cotton or spice was found, they know that people are coming to their location, people are coming to their continent, people are coming to their country to buy these products. So, when you know that these products have some kind of value, the people in that region started specializing in producing those unique products that they are famous for. And that is how, when people started specializing in those particular areas, ultimately the goods were being identified as originating from that particular place. So, the good was associated with a place. If you want this particular product, please go to this continent, please go to this country, please go to this location. That is how they connected the products with the content, with the location from where they are coming, and slowly all these products which were associated with certain kind of location became globally known. Word by wide mouth, you communicate, right? Or if you want this product, there you will get it. So, that communication, and globally all these products were known, that if you want this, please go to this country, if you want this, go to this country, go to this state, go to this location. That is how they linked the product with the geographical location. What happens? Once you become famous, you know there is a lot of demand from premium products, for premium quality goods, for high standard goods, for uniqueness. You know there is demand, and when you know that there is demand, there is also one element of wrongful practice that comes into the market of fake goods, fake products, counterfeited products. In that case, what is happening? First one, the consumer is suffering by getting a fake product. They have paid a high value for the product, but they are getting a wrong product, a fake product. That is wrong. They are getting a bad quality product. Second one, when they are getting a bad product in the name of original goods, the damage is being done to the reputation of the original goods. Even the genuine goods are at a risk of loss of reputation, and that impacts the producers of those goods. So, what is happening here? Here, because there is a lot of demand for good products, genuine products, People want to take advantage of that, and they issue counterfeited products into the market that damages the reputation of the actual genuine and original products. That causes a negative impact on the producers as well as the consumers. And to safeguard their interest, to protect their interest, they said that let's evolve a concept called as geographical indication, that people should get to know that these products, if you want genuine products, you have to go to this particular place. Only these people are permitted to sell these kind of products. Only these particular place you will get genuine products. And that is how the concept of geographical indication came into existence. But still we did not have any law for protecting GI. We have only associated or evolved the concept of GI. As of now, we have no laws for GI. Let's see how the GI Act came into existence. Okay. So what is GI as of now? We have identified that GI is a indication, a hint that a particular product is associated with a particular region because that region adds some kind of unique element, unique feature or characteristic to the product. And they decided that it is important for us to protect the interest of the producers and the consumers in relation to these GI products or GI goods, and that is why they said that let us classify GI as an intellectual property. So when you talk about intellectual property, intellectual property is classified into two forms. One is the industrial property. Another one is a copyright. Okay. What is industrial property? Industrial property has various subclassifications like patent, you have designs, you have GI, you have plant variety and protection. A lot of categories are there under the ambit of industrial property. So what is GI? GI is one of the categories of industrial property coming under the ambit of intellectual property rights. Okay. So GI, it is an industrial property whereby we are hinting that there is some connection between the place of origin of that product and the product itself. That this GI, the name conveys that there is some level of quality, that there is some level of distinctive feature, there is some kind of uniqueness in this particular product, and that is hinted from the name of the product itself, and that unique feature, quality is going to be there in the product merely and merely because it is linked to a particular place and that place of origin. You have that special characteristic merely because your product is coming from a particular locality, region or country. If you grow the same product somewhere else, you will not have that distinctive feature, you will not have that distinctive element, you will not have that uniqueness. Your product is unique merely because it is associated with one particular origin, it is related to one particular country, region or locality. That itself is GI, and we want to give protection to those products which are coming from a particular location carrying certain level of uniqueness. Let's have a look at certain examples, because I said that the product should carry some unique element. Let's have a look at what is the uniqueness. First example I've taken is of Mysore silk. It is not that silk is available only in Mysore. You have silk saris everywhere. But why is the Mysore silk sari so famous? Because the unique element is we are using the actual pure gold to do the zari work, to make the borders. Actual real gold metal is used to make those saris, and that is why they have such high value as well as reputation. Second one is Nagpur oranges, like we have already discussed. Oranges are grown not only in the city of Nagpur, but it is grown in multiple places even in southern parts of our country. But why is the Nagpur orange so famous? It is because the soil conditions and the weather conditions of Nagpur have certain level of higher acidic value to the product. Orange is an acidic fruit. That acidity is slightly higher in the oranges if they are grown in the soil of Nagpur, and that is the unique or distinctive feature of that product. If that orange is grown somewhere else, it will not have this feature. So, it cannot be known with the location. Because it is grown in Nagpur, it has certain quality, that is why it can be called as a geographical indication. Next, Banarsi sari, again it is one of the categories of saris. Here these saris are known for the work, that is the brocade work. It is a kind of craft that people have in designing these saris. You have the Darjeeling tea. Tea is grown multiple places in cities like Ooty, in places like even Coorg. But why is the Darjeeling tea famous? It is because of the altitude in which it is grown, higher regions, and it is grown in the Himalayan region, which has a distinctive aroma, climate, and because of that wind, because of that climate and weather conditions, the flavor of the tea is different. The aroma, the smell of the tea is also different. Coorg Arabic coffee, again because it is grown on a high altitude levels, it has a distinctive aroma and mild acidity is also there in the coffee. You have Naga chilies from Nagaland or Assam, which is also known as one of the world's hottest and spiciest chilies. Okay, it is because of the location where it is grown. Few more examples, Kashmiri saffron from Jammu and Kashmir. It has a deep red color. It is used in medicine, medicinal properties also there. It is used in cooking as well. You have Tirupati laddu, very famous. It is given as prasad in the Tirumala temple in Andhra Pradesh. It has a special recipe of making that particular laddu. It is specific only to that particular location. Nowhere else you are going to get that laddu. Kashmiri Pashmina, like we have already told you, the Pashmina shawls, they are made from woolen, and that wool is nothing but Kashmiri wool, and that wool comes from the sheeps, and those sheeps are living in the region, Himalayan region, so they have certain high levels of quality. The wool is extremely soft. The Pashmina shawls are not very thick to give you the warmth, it is very thin, but still it gives high levels of warmth to the body to suit the weather conditions of that location. That is why they are famous for the wool of that location. Bikaneri Bhujia is a snack from Rajasthan. Again, Dharwad Peda is a sweet, Agra Petha is a sweet. They are known from their respective regions. So, what is GI? GI is nothing but one product which is associated with one location, and that location is adding the distinctive feature, uniqueness or element to the original product. These three things put together only can qualify as a geographical indication. Even if one of this is missing, geographical indication cannot be established. Now, why is there a need for protecting geographical indication? Why should we protect the goods? Why is there a necessity? We saw the basic requirement that a lot of counterfeit fake products were coming to existence. It was damaging the reputation of the original products. It was also giving bad products to the consumers. So, the interest of the producers of the goods and the interest of consumers both were put at a damage. A lot of misuse was taking place in the market, but we had no laws for protecting geographical indication. Only the concept of GI was established, but there was no law for safeguarding or protecting the interest of the producers or the consumers, and that is why we somehow led to the bringing into existence of the laws for the protection of GI. How did that happen? That happened because of a lot of misuse. How the misuse happened? In the absence of statutory protection, like I told you, we did not have any kind of law for protecting GI. In the absence of a law, the Indian geographical indications were being misused by persons who were outside of India to indicate that the goods originated from their location and not from India, because India never protected the goods from its own location. So, people could use it anyhow. They were saying that these are the products from their country and selling it, because anyways no protection was given to them, and that is how three major cases took place: misuse of turmeric, neem and basmati. Very important cases. This does not form a part of your syllabus at CS executive level, but understanding these cases lays the very strong foundation of identifying why the GI Act was brought into existence. Okay, so these three cases we are going to cover: how turmeric was misused, neem was misused, and basmati was misused. The outcome of these three cases led to the passing of the GI Act. These instances drew a lot of attention that we have to give a lot of protection to intellectual properties in the form of geographical indications. So one by one, let's have a look at the three cases. All the three cases, that is the neem case, turmeric case and basmati case, are based on one concept that is called as the traditional knowledge. What is the traditional knowledge? Traditional knowledge is a knowledge that is living. It is passed on from generation to generation. There is no documentation of it. It is verbal. It is informal in nature. But from grandmother's generation, we are getting to know certain kind of information. For example, as soon as you fall, you have some kind of wound. They say apply turmeric. It is a wound healer. Quickly it is going to heal. Or if you're feeling unwell, your body is feeling sick, they say add turmeric to your milk and drink. It is going to help your body recover because it has some kind of medicinal properties, turmeric. So these are the kind of information that has been passed on from generation to generation in Indian communities, in Indian family households. That is how it has happened. That itself is traditional knowledge. Okay, so what is traditional knowledge? It is a living body of knowledge that is developed and sustained, and it is passed on from generation to generation within a particular community, locality or family, which is forming a part of cultural and spiritual identity. It is our culture, it is our identity. We are known to do certain things. Traditional knowledge per se is it is the knowledge that has ancient roots. Thousands of years back these practices are going on, and it has been passed on from generation to generation. So they have ancient roots, but the negative aspect, it is so informal and oral, it is not documented anywhere, that it is very difficult to identify what it is, and it is very difficult to give protection to that knowledge which is not documented. And because we did not have a lot of protection to this traditional knowledge on turmeric, neem or basmati, the cases were there and we had to fight the battle with the other countries. So let's have a look at what were these cases. One by one, three cases we are going to cover and see how we had to mandatorily provide protection to the goods which are classified as GI products in India. First, let's discuss the turmeric patent case. What is turmeric? Haldi. It is known in India for so many properties. For skin care, we use turmeric. For antiseptic properties, we use turmeric. We not only apply turmeric, we also consume turmeric in our food, in our milk, right? Turmeric has so many benefits, right? For the entire body, it is useful, right from the skin to your wounds. Turmeric has a lot of medicinal property, and this is known to every small child in the house. That if I am feeling sick, mummy will give turmeric milk. It is known, even small kids know about the benefits of turmeric in India. But what happened here? What happened was, I've just given the basics, that turmeric is one of the herb that is grown in India. It is widely used as medicine, as food ingredient, also as a dye in some kind of places. It is used as blood purifier. It is used to treat common cold and fever. It is used as antiseptic for skin infection. It is also used as an essential ingredient in cooking of Indian dishes. So many benefits are there of turmeric, and these benefits all of us Indian know, right from a small child to an elderly person. We know what is the use of turmeric. But what actually happened? In 1995, two Indian origin people were in the United States. They were researchers at the University of Mississippi Medical Center, and they were given a US patent. They had applied for a patent in the United States for the use of turmeric powder in wound healing. For wound healing, they had said that turmeric is useful, and these people have found that Turmeric is useful for wound healing. Wound healing. They claimed patent for it, that they are the people who identified it, they are the people who innovated it, they are the people who discovered or identified that turmeric is useful for antiseptic properties. They claimed a patent and US granted the patent and the patent was given to them. That is when India came into the picture and said that how can you give patent for this, because this is not new, because what is the quality for registering a patent? It should be new, it should be innovative, it should not be in existence before. You are the person who has innovated that product or innovated that thing. But this concept is known in India thousands of years back. It is not new at all. It is already in existence in India from years together. It is not new that turmeric is going to be used for wound healing. We are using the turmeric for wound healing from thousands of years. So this is not new. Why did you give patent to this? They asked proof. Where is the proof? From when are you using? But what is it? We have everything informal. Everything was oral. It was passed word by word through generations. No document is there. Then India sat and did so much research. They went back to the historical documents and tried to find traces of evidence that anywhere in any document they have mentioned that turmeric is being used for so and so reason. And during the scope of their research, they found documents in various languages, Sanskrit, Urdu, Hindi, where it was mentioned that turmeric is used for so and so, and they produced these documents before the authorities in the United States and said that, see, this is already there, these documents are thousands of years old, don't give them patent. And that is when, after a lot of research work, battle with the United States, the patent that was given for these two people on turmeric was revoked. Okay. So the patent claimed that turmeric had certain healing properties when applied to the wounds, which is already a very well known practice in Indian traditional medicine, not only in Ayurveda, even in Siddha and Unani. These are various different categories of medicine in India. Okay, in all these forms, for centuries together, we have been using turmeric as a very important ingredient carrying medicinal property. So that is when the Council for Scientific and Industrial Research of India challenged the patent that was granted in 1996. In 1995, they applied for the patent, they got it. In 1996, India filed a claim that this is a wrong patent, you have wrongfully granted the patent, it is not right. See, the authority, the council that challenged the patent that was granted, argued that the turmeric's medicinal use was not new, it was not novel, it is not a new idea, it is not something that has been discovered, but it is an existing traditional practice, making it a prior art. It is already in existence, it is already a known knowledge. So patent cannot be given to anything that is already in existence. And though it was a well known fact, but still the use of turmeric was in every household. But it was a very, very Herculean task. It was a difficult task to find a published material to prove that we are using turmeric from how many generations. It was very, very difficult for us to search for those documents, but somehow India was able to gather evidence, ancient Sanskrit texts, scientific papers, industrial medicinal literature. In multiple languages, we were able to identify 32 reference documents in which were either in Sanskrit, Urdu, Hindi. After extensive research, these 32 documents were identified where it was mentioned that turmeric has medicinal properties, and these are already published in India many years ago. This was given as evidence in the courts, and it was proved that turmeric having medicinal properties not something new. It has been in practice in India for thousands of years, and on the basis of the evidence that was given by the Council of India with respect to medicinal science, the United States office, patent office, revoked the patent that was given to those two young people on the grounds that it lacked, it did not have anything new, novelty criteria was not satisfied, and that is how the traditional knowledge that belonged to India was safeguarded in the Turmeric case, because India fought that battle with the United States. This case has set a very important precedent for protection of traditional knowledge and preventing any biopiracy. Okay, so very important case in the history of India. But what was the impact of this decision? The impact of decision was, back in India, people decided that we should have a library for traditional knowledge. Okay, so they decided that we have to create one traditional knowledge digital library in our country to prevent any further misuse of indigenous knowledge. Indigenous knowledge is the knowledge that is there in India for years together. So it is for us now to accumulate all the data together and create a database, create a digital library where all the traditional knowledge that we have, everything should be documented properly, so that India's products, India's knowledge, India's culture is safe and it can be protected in case of any disputes. That was the impact of this judgment, that in India we have now established the traditional knowledge digital library. This has strengthened the global efforts to recognize and safeguard traditional knowledge from unauthorized patents. We should not grant patent to people if there is traditional knowledge already in existence, and Turmeric case is the best example for that. Similar to what happened in Turmeric case, also happened with one more important ingredient, that is the Neem case. Neem patent case, this is with India versus US and Europe. What is the special characteristic of Neem, or why do we use Neem in India? Again, it has medicinal properties, antibacterial properties. We use it for skin care. We use also when we have chicken pox, they use Neem water, Neem leaves to cure the skin disease, skin infection. Right? It has, even eating Neem leaves, they claim that it is good for monitoring the blood pressure. So Neem has a lot of medicinal properties, and this is known in India for generations together. But again, for the same thing, a patent was claimed by people from a US company, US firm. They claimed a patent. Let's see. Neem tree has been used in India for centuries for medicinal and antibacterial and pesticidal properties. Even it is used as a pesticide for plants. In 1995, the European Patent Office granted patent to W.R. Grace & Co. This company is the company of the United States, US company, had applied for the patent in Europe region, and Europe had granted them the patent. Okay. For what? For antifungal properties of Neem. They derived a formula from Neem leaf and Neem product that it has antifungal properties, and we have invented this new thing. For that they filed a patent. The patent is based on the method of controlling the fungus on plants, comprising and contracting the fungus with Neem oil formulation. So they said that we have generated one liquid, one product through which you can protect your plants from any kind of infections, fungus, anything. So it can be used as a pesticide for the plants. By using the Neem oil in the formulation, you can protect the plants. It has medicinal property, antifungal property it has, and that product they wanted to patent. But what happened? Indians, scientists, the farmers in India, the activists in India, all came together and they filed and challenged the patent that was given to those US firm and the US Agricultural Department. We argued that, we means India as a country, we argued that the Neem's property were already well known in the Indian society. It is a traditional knowledge, that it is a living knowledge. Generation to generation we have known about the properties and the values of Neem. and the patent, if granted, would be an act of biopiracy, and therefore the patent should not be granted. It is a traditional knowledge prevalent in for years together, thousands of years together. So it is nothing new that Neem carries antifungal properties. It is wrong claim that it is something new. It is already existing in India, and this was proved by giving a evidence supported by ancient texts and traditional uses of neem in agriculture as well as medicine. We were able to prove it. We were able to give them a lot of evidence, and on the basis of the evidence that we submitted Ayurvedic text that hydrophobic extracts of neem seeds were used for centuries in India, both in dermatological diseases in humans as well as in agricultural plants from fungal infections. So it is not only can be used for human body infections, but it can also be used in plants for protecting them from fungus. From its roots, the entire tree, neem tree, is useful, right from its bark, branches, leaves, everything. Okay, the roots of the spreading crown, the neem tree contains a number of potent compounds, notably chemical found in seeds, is used as an astringent in so many fields. The bark, we used to use the twigs, neem twigs, to brush our teeth in ancient times. Even today, when people are fasting in India, they don't use the regular toothpaste. They actually use the neem twigs, neem sticks, neem branches to brush their teeth, right? So the neem barks, leaves, flowers, seeds of neem tree, everything is used in India for some reason or the other, and it has a lot of benefits and a lot of benefit properties. The same neem twigs are used as antiseptic toothbrushes since time immemorial. So every part of the neem tree is being used in our country for generations together. In 2000, the European Patent Office has revoked the patent that was given to that US firm and the US Agricultural Department after reviewing the evidence that was submitted by India. EPO has identified, again on the same grounds, that there is no innovation, there is no inventive step, and it is only based on the traditional known. On the basis of this, it was declared that the patent which was given is invalid, but the US firm challenged it and preferred an appeal further. But even in the appeal, it was held that the patent is invalid. India has the traditional knowledge and they have been using it for generations together, so we cannot give you the patent. That is how we protected our knowledge, our culture in reference to neem as a product, and we got the protection. Means they did not protect, they did not recognize that India is known for it, but they just said that nobody else is permitted to use. Till now, even in turmeric, they said that the patent will not be granted, but it was never said that protection will be given to the Indian turmeric. No, protection was not given, but they stopped the others from making use of it. They stopped the others from getting patent on the traditional knowledge. Same thing happened in the Basmati patent case. What is Basmati? Basmati is one kind of rice which is grown in the northern region of our country, Pakistan region and other higher altitude regions. But there was a patent that was filed in the United States claiming that this is a new variety of rice. And US is known for this variety. They have created a hybrid version, and that has been invented in the United States. So they claimed a patent on one of the variety of rice. Again, the outcome was in our favor. Let's see. In 1997, a US company called as the Rice Tech Incorporation was granted US patent for a new variety of Basmati rice. The patent covered certain rice strains which were grown outside India and Pakistan with characteristics which are very similar to the traditional Basmati rice that we grow in our country. The Rice Tech also attempted to market its rice as American Basmati, which also threatened the export of India's Basmati rice. They started saying that it is the American Basmati. So what happened? It is going to ultimately impact the original Basmati that is grown in India. The exports from India would be impacted. So to avoid this kind of scenario, India has challenged the decision. India has filed a case, and we have filed objection that you cannot grant the patent to Rice Tech Incorporation because The Basmati rice is traditionally grown in India and Pakistan, and it has that unique characteristic because of the climate, because of the soil in that particular region. Basmati is not even available or grown in the southern part of India. It is only exclusively in that belt, in that particular northern region, that Basmati is grown, because only that soil and only that climate can give that unique feature. So when they say that it is American Basmati, we will not accept that fact. It is not right. Okay, claims regarding certain characteristics of Basmati with respect to the starch index, with respect to the aroma, with respect to the grain dimension, the length, the width, the size of one rice of grain. All these are unique features of Basmati, and that is why they challenge that it cannot be given to America. The term Basmati is a geographical link to South Asia, making rice text claim misleading. India provided enough scientific and historical evidence to prove that Basmati was an indigenous variety which is grown only in one specific region by one particular locality. The outcome was that from a lot of pressure from Indian farmers, Indian industries and certain other countries which supported us, and the international trade bodies also pressurized, the US Patent Trademark Office has struck down the key claims of the Ricetech patent, and Ricetech was asked to withdraw the claim over Basmati. They said that you think that it is a rice grain from the United States, you can sell the product. We are not saying that stop producing the product. You can sell that rice that you have, the hybrid version that you have created, you can sell it, but you are prohibited from using the name Basmati. You can sell it with any other different name, but don't call your rice as Basmati rice, because Basmati rice is only available in the Indian northern region and earlier Pakistan, because we were clubbed as a country. So nobody else is permitted to sell the rice in the name of Basmati. You have created this hybrid version of Basmati, okay. We are not stopping you from selling it. You sell it in the market, but you cannot call it as the Basmati rice, because Basmati rice is only indigenous to our region, to our northern part of the country. And that is why the patent was not yet granted. It was still to be granted, but they said that you please withdraw the claims. You don't claim that it is Basmati version, you take the patent in some other name, you take it in some other aspect, but you cannot call it as Basmati rice. Impact. The case reinforced the importance of protecting the geographical indications, leading India to secure a GI status for Basmati rice in 2016. Recently in 2016, we have got a GI tag for our Basmati rice at the global level. This strengthened India's effort to safeguard the traditional agricultural products from biopiracy. So all these three cases have given a very good lesson to the country that you have to protect your own products, otherwise the foreigners are going to make misuse of it. The other countries are going to misuse your knowledge, the other countries are going to misuse your products. It is for you to protect your own products. But what happened? Why can we not take protection for our products? Because under the TRIPS agreement, there is one clause. The clause says that until the product is not protected in the home country, we will not give protection in any other country. We did not have GI Act. Other countries had provisions for protecting geographical indications. So even if India wanted to claim protection for its products in any other country, that protection was not given because one condition is attached. If it is an Indian product, first the Indian government should protect it, the Indian law should protect it. If the home country protects the products, only then the foreign country is allowed to protect that product. But because in India we did not have laws itself for protecting geographical indication, we cannot claim protection in any other country. So what did they do? They did not give us the right exclusively to use those products, but they prohibited the others from misusing it. Only that much happened. But we did not get any kind of protection that we have the exclusive right to use and sell these products. That protection was not given. And because of this clause, we had to pass the GI Act. There was an article in the TRIPS agreement, which said that there is no obligation for any other country to extend reciprocal protection unless and until the geographical indication is protected in the country of its origin or the home country. If India wants to protect Nagpur oranges, first Nagpur oranges should be protected in India. You should have a registration. Then you take registration in other foreign countries. They will give protection to your Indian products only if India is protecting it. But in India, we had no laws only for protecting GI. So we could not claim protection for any of our products in any of the other countries as well. Because of this clause, we had to pass the GI Act. India did not have any specific law for protecting geographical indication which could adequately protect the interest of producers of such goods. This was one reason, and second reason is we also became signatory to the TRIPS agreement. We also signed the TRIPS agreement, and when you know that you are a signatory to an international convention, international document, whatever is a mandate in that document, we have to implement that at the national level by passing laws in the country, and because of that obligation also we had a responsibility of passing the GI Act. To cover up such situations, it became necessary that we have a comprehensive law for ourselves. We had to provide for a proper registration procedure, and we had to give proper protection to all the GI products, and that is when the GI of goods, that is Geographical Indication of Goods Registration and Protection Act of 1999 was enacted. This comes under the same provisions. You have the geographical indication registry, the registrar is there. It comes under the controller of patents, design and trademarks. Under that ambit itself, the same department is going to handle even geographical indications. That is how came the GI Act of 1999. Okay. Why was there a need to pass GI Act? I already told. One was because we had, if we wanted protection of our products from being misused by any other country, first requirement was as per TRIPS agreement that we at the national level, if protection is there, only then at the international level we are going to give protection, or else we are not going to give protection. So upon that, India also became a member of the TRIPS agreement, because of which there is an obligation that you have to pass the laws at the national level. So the general rule is, if you are a country and you sign any document or any law at the international level, international law, that law should also be implemented at the national level. You should be compliant. You should be in compliant with the international standards of law if you are a signatory to that transaction. So as a country, we had to adopt the TRIPS agreement provisions at the national level, and because we did not have laws for the GI, we had to pass the GI Act. Okay. What is the objective of the GI Act as per the preamble? It has three main objectives. First one is, we wanted a specific law. We did not want multiple topics of intellectual property under one enactment. We wanted different enactment for different intellectual properties. Patent, separate act. Design, separate act. Trademark, separate act. Copyright, separate act. So like that, even for geographical indication, we wanted a specific law that is going to govern the geographical indication. What is the procedure? How are we going to give protection? How we are going to protect not only the goods but also the producer of those goods. So we wanted a specific enactment for GI exclusively. Second one, we wanted to exclude the unauthorized persons from misusing the geographical indication and protect the consumers from the deception that these are correct products. So we wanted to give protection to our products. Nobody else is allowed to use the products or wrongly sell their products as our products. Okay. Last one, to promote the goods as Indian GI goods and increase the exports from our country. Because GI goods, what it has certain level of uniqueness, it has some distinctive characteristic, it has some high level of quality standards. Because it classifies all this, it is capable of generating a lot of export income. So it is a product that can be exported on a large scale. So we want to promote the Indian goods which carry these characteristics and uniqueness, and to promote that we should give them recognition. To give them that export and boost in their business, we have to give them protection, and for these three reasons we have passed the GI Act of 1999. Coming to the main foundational document for GI, it is the TRIPS Agreement, World Trade Organization's trade related aspects of intellectual property rights. In that they have defined a geographical indication. What is the definition? They say a geographical indication is an indication or a hint which identifies a certain goods as originating from a particular territory or a particular country or a locality, where because of that locality you have some kind of quality, you have some kind of reputation, or you have some kind of distinctive characteristic, and that characteristic or uniqueness is attributable only because of your geographical location. This is the same link that I have established at the earlier parts of this session, that there should be a product, there should be a geographical location, the product should be grown or manufactured in that particular location, and that location is going to add some kind of value to your product, that location is going to add some unique feature to your product. If this link between the product, location and the characteristics of the product is established, only then we can call it as a geographical indication. So this is the definition of GI as provided under the TRIPS Agreement. Now let's see what is the definition that is provided for geographical indication under section 2 subsection E of the GI Act of 1999. It is a very long definition. I have simplified by putting it into pointers. What is it? Again, it is based on the definition given under TRIPS Agreement. Whatever we have covered now, all those elements are present, but a detailed definition is given to us. Let's go through it. They say geographical indication in relation to goods. So they have specified it is only applicable to goods and not to any kind of services. So geographical indication is related only to goods. What is it? It is an indication through which we can identify that one particular product, one particular good, that good can either be an agricultural commodity, agricultural good, it can be a natural good, it can be a manufactured good. Any category, does not matter. So this specification has been given in Indian definition. What kind of goods? Goods can be agricultural, natural, manufactured, handicraft. And these goods are originating. If it is agricultural and natural, it is originating. If it is manufactured, then it is manufactured in the territory of a particular country, a particular region, or a particular locality in that particular territory. So what have we identified? Firstly, it is an hint that a particular good, that could be agricultural, natural or manufactured, and if it is agricultural, natural, it is originating from that particular locality. If it is manufactured good, it is manufactured in that particular locality. And third one, that the quality, the reputation and characteristics of that product is linked, attributable, it is linked to the geographical location. So there is a product, it is linked to a geographical space, and it has some unique characteristic that is attributable to the place of its origin. And in case, okay, that itself is the definition. It is similar to what we have seen in the basic concepts as well as the definition of the TRIPS Agreement. It is a good originating from a space, and that particular place is contributing to its key factors, characteristics or elements. Now, when you talk about manufactured goods, the last category of goods, what is the requirement? The requirement is that one of the activities, either of production or processes or preparation of the goods, should mandatorily take place in that particular territory. If you say it is a Mysore sandal soap, you call it as a Mysore sandal soap, you want to claim protection for that product in the city of Mysore, in the state of Karnataka. But the entire manufacturing process or any preparation work, nothing is carried out in the state of Karnataka. All the work is being done in Tamil Nadu. we cannot give you protection. At least one work related to the manufactured product should take place in the place of origin. That is the condition that has been attached for giving the GI tag to a manufactured product. That not necessarily the entire process should happen in that particular locality. One work, one process, one preparation work should carry out mandatorily in the place of origin from where they are seeking protection. This is the definition that has been provided for the term GI under section 2 subsection E of the GI Act of 1999. Further, they have said that it is not mandatorily that the product should include the name of the city, name of the locality. Like whatever examples we saw, Mysore sandal soap, Nagpur oranges, Kolhapur chappals, we saw Kashmiri shawls, saffron, Kashmiri saffron, all this, the names are there. But even if name is not there, it can be classified as geographical indication. It is not mandatorily that in the name of the product, the name of the city, name of the location or name of the locality should be included. Even without that, GI registration can be done. So what they say, it may be noted that any name which is not the name of the country, region, locality or region shall also be considered as a geographical indication only if it relates to that specific geographical area and is used upon relation to that goods which are originating from that place. You just have to prove it that it is originating from this place, it has unique characteristics and this is the product. But we don't want the name to be there in the name of the product, but it is still a GI product. So the mandate of having the name in the name of the city or name of the locality in the GI tag is not mandatory. Even without having the name of the locality, you can have a GI tag, but you just have to prove that all these three elements are present. Okay. So on the basis of the definition that we have seen, the basic definition, the definition under the TRIPS agreement and the definition that we have seen under the Indian GI Act of 1999, what are the basic characteristics of geographical indication that we can identify? First one, it is a hint, it is an indication, it is an identification that a particular product is linked to a particular, it is definite and associated with a particular geographical location, and it is used to identify certain goods, only exclusively goods that belong either to agricultural sector, natural goods, manufactured goods. So what is the element? Goods. So what is the first thing? That it is a identification, it is a mark, it is an indication with respect to some kind of geographical location, and that geographical location in relation to some kind of goods or products. And in case it is a manufactured good, in that case one more additional condition is imposed, that any one work, either the production or the process or the preparation in relation to the manufacturing of that product, should mandatorily be carried out in the territory with which it is associated, and this good or this product should have some kind of special quality, special reputation or special characteristics which is attributed to the geographical territory. So these are the basic elements and characteristics for establishing a product as a GI product. Now, we have been saying that geographical indication is applicable only to the goods, right? Only products. So what are goods as per the GI Act? They say that goods can mean anything agricultural, natural, manufactured goods or from the handicraft industry or any other industry, and food stuff. So they have given 4 classification of goods. You can register your product under any one of these categories, either agricultural and natural, or as manufactured, or as handicraft products, or as food products. Okay, we have seen various examples. Again, let's take example from each one of these categories. For example, first category is agricultural goods or natural goods. I have taken tamarind, agricultural product. Okay, it is a variety which is grown in the Maharashtra's Latur district. It is one of the village in Maharashtra where they have this variety of tamarind. But what is the feature or special characteristic, it is juicier and longer than any other tamarind variety that is prevalent in India or any other country. It has medicinal property also. It helps in managing diabetes, helps in digestion, helps in weight loss, it helps in preventing ulcers, helps in stomach problems. For all these unique characteristics, this particular variety of tamarind is GI tagged. Some other agricultural products are Himsagar mango, Kailpad rice, you have jaggery from Kolhapur, Nanjangud banana, Malabar pepper, you have Coorg coffee. All these are agricultural products from agriculture, farmer background. Next, coming to the second category of goods, manufactured goods. Manufactured goods means goods which are brought into existence by human mind. Okay. So, in that case, I have taken Mysore sandal soap from Karnataka as the product. What is the unique feature of this product? This is known as the only soap in the entire world which is using 100% sandalwood oil for its manufacturing. Even the sandalwood oil separately is a GI product, and it is being used in 1916. See the time, how many years. Other examples of manufactured goods are Mysore agarbatti, Coimbatore wet grinder, Mysore sandal oil, champagne from France, you have fenny from Goa, you have East India leather from Tamil Nadu. These are all manufactured, not natural. They have been developed by humans, but still they are known from that location for certain unique characteristic, and that can be registered. Next. Third category of goods is the handicraft goods, that is some kind of craft, some kind of skill element, and we as Indians have a lot of culture, lot of traditional, we have a lot of traditional knowledge and lot of skill, okay, and that should be appreciated, and that is why we are promoting a lot of handicraft products. The example that I have taken is the Chanpatna toys and dolls from Karnataka. The exclusive feature is all these toys are made from wood. Okay, these are all wooden toys and dolls. It is a traditional craft, and we want to protect this particular craft, and that is why we want the protection for these products. Only a few people know how to work about or go about it, so we want to give protection to that group of people who are indulged in making these wooden toys. Other examples of handicraft goods is Konark stone carving from Odisha, blue pottery of Jaipur from Rajasthan, Kolhapuri chappal from Maharashtra, Chanderi saris from Madhya Pradesh, Tanjavur paintings from Tamil Nadu, Petapur printing blocks in Gujarat. So, a lot of work is there, a lot of handicraft elements are there that can also be protected. The last category is the food stuff. Locations are known for its food also. So, I have taken Ooty Varki from Tamil Nadu. It is a snack, crispy vegetarian snack from Nilgiri district of Tamil Nadu. Unique feature is the ingredients that is used, the preparation procedure, and the flavor that it carries because of the weather conditions of Ooty. Other examples are some fermented fish from Assam. It is called as Bodo Napam. Bikaneri Bhujia from Rajasthan. You have Halim from Telangana. You have Banaras se Thandai during Holi. You have chutney from Odisha. You have honey from West Bengal. So, these are various categories of food stuff which can seek protection. So, under the GI Act 1999, we have various categories of goods: agricultural, natural, manufactured goods, handicraft goods, and food. Under these, whatever product you have, you can seek protection if it is related to one location and has some kind of unique or distinctive feature. That is goods. Next is, what is the term indication? Indication means we thought that it is some kind of hint. It is some kind of identification that a particular product is belonging to a particular locality. So, what is the definition? They say identification can include a name, geographical representation, figurative representation, or a combination of name, geographical representation or figurative representation. It can be a logo, it can be only a word, anything is possible. It is conveying and suggesting that the geographical origin of goods to which it applies. The name or the product is linked to a product that is being hinted or conveyed through either the name, the geographical representation, or the figurative logo, whatever they have. Now, we have understood what is GI. We also know that a GI Act has been passed for the purpose of protecting the geographical indications. If you want to protect, first basic requirement is registration, to know how many products are there. So, if you are a person who is in possession of a product which is capable of being called as a GI product, then it is for you to make an application to the registrar for registering your product as a GI product. In India, as of now, we have 658 products as a GI protected products. A GI can be registered for goods only which is classified by a particular region, locality, or location by submitting an application to the registrar, and the classification of goods is going to be done on the basis of the international classification system, and it is going to be published in an alphabetical manner, mainly because if every country follows the same way of classification, it becomes easier to give protection at the international level. If India is following a different mechanism of protection, different system of protection, internationally they have a different system, it is very difficult to tally both while giving protection. So, they say that it is better whatever is there in the TRIPS agreement at the international standards, all the countries, if they follow the same pattern, the same number, same class is given, then it becomes easier for protection. So, India also has adapted the international standards of protection for classification of goods. If there is any dispute about whether a product comes under category A, B, C, what is the category, what is the classification number, because every good has a number, okay. So, if you are belonging to a particular class, you have a dispute under which one of the clauses we should seek our registration, then whatever is the decision of the registrar, that decision shall be final. You might say class 1, they might say clause 5, which is the class under which you have to seek protection. So, if there is a dispute under which class you want to protect your goods, the registrar's decision is going to be final. Once you make an application as a producer or as a community who together are making an application for the GI product, if no opposition is filed from anyone, or if opposition is filed but that opposition is not considered and the decision is given in your favor, in that case the registrar is going to grant the registration of GI, and this registration is going to be given to two categories. One is that the GI product itself is safeguarded. One more protection is for authorized users who are permitted to manufacture, who are permitted to grow, who are permitted to sell those GI goods. So, protection is given to the product. In addition to that, the product is all protection is also given to the user who is permitted to sell the products using the GI tag. So, two protections are given, one for the product itself and one protection is for the users who are going to sell these GI products, authorized users. To both, protection is going to be given, and the protection will be given from the date of the original application. Now, what is the benefit? Why is there a need for obtaining a registration? All of us already are aware. First one, for legal protection, in case anybody else is trying to sell their products as a GI product, but they are actually fake, they are not right, they are not original, they are not premium, but still they are being sold in the name of your products, they are passing off their goods as the original products, you can have legal protection. Legal protection should be given. Second one, it prevents unauthorized use. Somebody who is not an authorized user, somebody who does not belong to the people who have filed the application for protection, you are not permitted to sell the products. So, unauthorized use of the products is going to be stopped and only genuine goods are going to be there in the market. Third, to provide legal protection to the Indian geographical indication, which in turn will improve the exports. If you protect the Indian goods, if you give them that recognition, then at the international level it is going to add value and the exports can be increased, and also you can seek protection at the international level if you are protecting them in India. Next one. This also promotes the economic prosperity of the producers of the goods which is produced in that locality. So, you are not only developing the country by increasing the exports of your country, but you are also helping those producers. The handicraft work which has almost lost its significance is gaining the significance back, and all those people, all those craftsmen who have that necessary skill, who have that high value skill, they can also now improve, they can also grow themselves, they can have economic prosperity because their products are getting recognition, they can export their products. So, it is not only helping the country, but it is also helping those craftsmen, it is also helping those producers, farmers to gain economic advantage by getting a GI tag. Now, what are the rights that are given to the people once you get the GI registration? Like I told you, two kinds of protection is given. One protection is given to the product itself. One more protection is given to the user. So, what are the rights we are giving? First one, we are giving you the right to seek legal action for infringement. What is infringement? If somebody else is selling their product as a GI product, but that is not a GI product, they are selling fake products under the umbrella of GI product. Okay, in that case we call it as an infringement, and the people who have this GI registration, they can file a case against the people who are misusing their name, who are misusing the GI tag to sell wrong or fake products. That is the first level of protection. Second one is we are giving the exclusive right to sell the GI goods only and only to the authorized users. Nobody apart from the authorized users will be permitted to sell the GI products. Exclusive right of usage and preventing the others from using it. These are the two basic rights that are conferred upon the people who file an application for GI registration. So, the next automatic question comes is, who is going to file this application? Who is going to make an application? So, generally what happens, if it is an agricultural product, all the farmers are going to create one association, and in the name of the association we are going to file an application for registration. That means whichever farmer is a part of that association, they will be called as authorized users, and those farmers are permitted to sell their goods under the tag of geographical indication. So, it is not one person generally who can file an application for GI. It is of one particular region, and in one region so many people are residing. So, who will have the exclusive right? You cannot give that exclusive right only to one person. Always GI is given to a group of people because it is of community, it is of a particular region, it is of a particular locality, and every person from that locality should have a right to make use of that. So, in that case we say that GI application is not made by an individual person, it is never granted to one person, but it is always granted to community, it is always granted to association of persons or a group of persons. Okay. Next, the rights conferred, continuation. It is an exclusive right subject to any condition or limitation which is imposed by the registrar at the time of granting the certificate of registration. If multiple people are authorized users, like I told you, it can never be one person. Collectively, a lot of people will be engaged in that particular activity. That is why we cannot give an exclusive right to one individual over any other category of people. Collectively, all of them have this right, and no individual one person can hold a GI tag. But there is no exclusive right in the name of one person. But when infringement takes place, we are going to consider as a single user. All the people who have this authorization of sell the products, they will be considered as one person, and as one person they can fight against the third parties for infringement. Individually we cannot give exclusive right to one person. collectively the community members should make use of this GI tag. But when a third party is infringing your products, only one person can also file a case against the third party for infringement. Generally, there is no exclusive right, but in case of infringement, to fight a case against third party, even one authorized user will be considered to have an exclusive right over that GI. So, these are certain basic elements of registration procedure. Next, if you are claiming registration, is it a permanent registration? The answer is no. Generally, the tenure is 10 years. For once, they are going to give registration for 10 years. At the expiry of 10 years, further you can renew for further more period of 10 years. Okay. So, it is 10 years and it may be renewed from time to time, and this is with respect to the registration of GI for the product. Now, talking about registration of the authorized user, because we are talking about a community. In one community, thousands of farmers might be there. And those farmers might later also, after GI is given, they might want to take up the manufacturing or production or the growing of these products, right? In that case, they also have to take registration that this is the GI product. Now, I will be involved in making, manufacturing or growing whatever category of product. I am going to deal with this GI product. I want registration. You should prove that you are a person who is eligible to grow that GI product or manufacture that GI product. In that case, for the authorized user also, we have registration for a period of 10 years. Or if the GI registration is done in the year, for example, 2010, but you are an authorized representative, as an authorized user, you have taken your registration in the year 2012. Till when are you going to have registration? Is it 10 years from 2012 or is it 10 years from 2010? It is 10 years from 2010, because by 2020, after 10 years, the registration of GI is going to lapse and they have to renew it. So, it is 10 years or the period till when the date on which the registration of GI in respect of the authorized use is going to expire, whichever is earlier. Either 10 years or till the date of registration of GI. If GI itself is not registered, what will the authorized user sell? Because he is seeking registration to use this GI product. If the GI product itself is not renewed, if the GI product itself is not protected, what registration is given to the authorized users? So, it is either 10 years or the date till which the GI product is protected. Whichever happens earlier, till then the authorized user has protection. Once the period expires, obviously they have an option of renewing the application, renewing the registration. So, again an application is required to be submitted to the registrar in the prescribed form along with the necessary fees, and the registration is also further going to be given for a duration of 10 years. That 10 years is from the expiry of the original registration or last renewal. That means first year registration is 2000 to 2020. At 2020 you should take registration. Next is 2021 to 2019 it should be, okay, and 20 to, let's assume 2030. Next is 2030, 2040. It's 1, okay, 11, 1, 1. In this case, this is the first year of registration. So, the renewal will be for further 10 years from the date of expiry of the previous original registration. In this case, it will be further renewed for 10 years from the date of previous renewal date. That is what they mean, last renewal date or expiration, whichever is the case. Okay, and the renewal will be given and will be required both for the product itself and for the user. So, the registration of the product also should be renewed. The authorized user should also register and renew their registration. Then comes to removal and restoration. At any point in time, if you fail to pay the renewal fees, you have not made an application for renewal, timely payment is not made, in that case, the removal can be done of the authorized user from the register because there is non-payment of necessary fees, but it can be restored within 6 months to 1 year by submitting the necessary application to the registrar. Once the application is received with the appropriate fees, we are going to restore and renew your registration for further period of 10 years with or without any kind of conditions. So, at any point in time if you fail to register, you fail to pay the annual fee, the registration fees or renewal fees, in that case the registrar has the right to remove the name of the product from the GI registry. If you want the name back within 6 months to 1 year, you have 6 months duration to make an application for restoring the name back to the registry. They will do only if you make an application and submit the necessary fees. Once you give the fees, again they are going to add back your product to the GI register. As of now we have 658 products. So, what is the ultimate thing? The geographical indications protect the authenticity of the product, the heritage and the culture of a particular region, locality and community. It gives reputation to the local products while it is still benefiting the farmers, it is benefiting the artisans, it is benefiting the country and the economy as a whole, in addition to the customers who are getting the premium products, standard products and quality products. This is the basis of the geographical indications. You have the procedure of registration, what happens when infringement is there, what is the difference between GI and trademark. These are the topics that are covered in the enactment, but we are going to limit this entire session on basics of GI, what is the registration requirement, duration of registration and what is the benefits. With this, let's end the session. If you all have any doubts with respect to the session, you can put it in the comments below and we will answer to all your queries. If you want more updates about the CS course or any new amendments that are being brought about, you can join our WhatsApp community. The community link is provided in the description below. Happy learning.